Hi, my name is Romina Ruelas. I am a graduate student at National University working towards a Master's in School Psychology with the PPS credential. The purpose of this video is to discuss a current ethical or legal issue at my school site. I will be utilizing the ethical and legal decision-making model to address the current issue. According to Armstead and Jacob, 2011, the ethical decision-making model provides a suggested mechanism for critical thinking and planning for the resolution of ethical dilemmas. An ethical decision-making model is a tool that can be used by professionals in the education system to help develop the ability to think through an ethical dilemma and arrive at ethical decisions. The current ethical or legal issue at my site deals with the assessment of children with special needs. The current mainly issue revolves around speech and language assessments. As we all know, assessments of children with academic, emotional, or communication disabilities requires extraordinary attention to ethical issues, not only because of the special vulnerabilities of these children, but also the complicated nature of their conditions. These assessments necessitate a qualitative and developmental approach in which speech and language pathologists adapt the test administration and interpretation in order to meet the unique needs of the student. But what happens when a simple frequent mistake in administration or scoring interfere with the student's welfare and best interest? I will discuss one of the many ethical and legal dilemmas in the education system. The dilemma arose when our site speech and language pathologist recommended during a triennial IEP meeting that a student no longer qualified under the disability category of speech and language impairment, known as SLI. As we all know, parents might have different reactions to this information. On one hand, we might have very happy parents, glad their child no longer needs the extra supports and services. On the other hand, we might have concerned parents, thinking the school wants to take away services and supports that have made their children progress throughout the years. At our site, this was the case. A parent became very concerned when the SLP informed her child no longer qualified for such services. The parent claimed her child still needed those services and did not agree with the SLP recommendation. Following the decision, the parent went to talk to her child's private speech and language pathologist. As we know, educational assessments differ from medical practitioner assessments. Under the education model, the goals and objectives are about the student's educational goals that are in the IEP. While in the medical facility, the goals and objectives are based on some type of physical impairment or medical need. Under many circumstances, parents utilize medical private practitioners to serve as their child's advocates. The pathologist reviewed the school's SLP report and encountered many discrepancies in scores and descriptors of scores that majorly impacted the school's SLP recommendation. Mother expressed her concern for her child and children from other parents that might have the same situation but are not aware of it. Parent petitioned to have the situation addressed in the meeting notes. She emphasized she would not undergo with a due process, but requested that her child be tested again by another school SLP using the same assessments. Luckily, the parent and team came to an agreement prior to the parent considering a due process. According to the Individuals with Disabilities Education Act, IDEA, a due process hearing is like a courtroom trial for the school and you. During the hearing, parties can call witnesses, give evidence, and make legal arguments. A trained hearing officer acts as a judge and makes decisions about the case. The decision may be in favor of the parent, the school, or in favor of both. Therefore, my site team saved themselves from a long and complex situation. Moreover, Mother also expressed her concern for other parents and emphasized the school SLP should be reported to her superiors. My supervisor apologized for the situation and expressed that it was possible to retest the student. During collaboration with my supervisor, a lead SLP, and school administrators, we reviewed the case. And in fact, the school's SLP who conducted the assessment made major mistakes in her report, in which her recommendation was inaccurate, and the student continued to qualify under SLI. As a school team, we are obligated to take responsibility for the actions of one of our own, following the ethical and legal guidelines. We are also obligated to find a solution for our concerned parents. A new SLP provided by the district reassessed the student and found him eligible under speech and language impairment. Possible major negative implications would have been if these parents filed for a due process, or worse, inform other parents with students with speech services about the situation. As school psychologists, we are responsible for providing alternative decisions and taking responsibility for the situation. Some key takeaway points from this case are: always make sure to verify work prior to presenting them at meetings to the parents. Make parents feel like they are an important part of the IEP team. If you make a mistake, admit it. Give parents revised copies of evaluation reports before the meeting. Always act in benefit of the student's best educational interest. I hope this video helps others who might have similar situations throughout their professional careers. More importantly, I hope others see the benefit of utilizing the ethical decision-making model to find solutions to ethical and legal dilemmas. Thank you.